Hi, and welcome back. It's right on time for our first panel of the day. The panel is going to be about expanding the powers of competition authorities. Rosa Warning, an associate at Freshfields, is going to be moderating it. The panel also gained from the help and work of Anna Popovici, David Perez de Lamo, and Oriane Limousin, a competition economist in Brussels. Just a quick housekeeping tips. For participants in the room, you're going to have the chance also to ask questions after the panelists open the debate. For that, you just have to raise your hand and someone will bring a microphone to you. For our remote audience, you just have to type a short question in the chat that you see in the screen. And then at a later point of the debate, we're going to have the opportunity of selecting some of the questions. When your question is selected, you can actually ask it yourself. So our tech team is going to unmute you and ask you to basically open up your camera. So please, when we say out your name and your question, please unmute yourself and put on your camera so that you can ask your question. So that's it. And let me give the floor to Rosa Warning, who's going to moderate the first panel. Thank you so much.
Thank you, Rossi. Very honored to be here today. And to open our first panel on the scope of powers of competition authorities. Before I welcome our panel, let me say a few words. Antitrust enforcement, business ecosystems, and social expectations have never been more intertwined. In our call for contributions, it was interesting to see the diverse challenges that people identified that they thought were a challenge for competition policy in the years ahead. Similarly, competition authorities around the world have advocated for reinvigorated antitrust enforcement to address industrial and public policy concerns. The wish to use antitrust to tackle broader social and economic issues beyond consumer welfare, including social and racial inequality, the decline of small business, and sustainability objectives, is widely heard. Our call for contributions confirmed this tendency. A legitimate question after any crisis is not whether a law or policy will change, but rather by how much. In the Commission's own words, it is currently pursuing a review of competition policy tools with unprecedented scope and ambition. All competition instruments, merger, antitrust, and state aid are being revised to ensure that they remain fit for purpose. Yet, an important question that the Commission and other competition authorities will need to ask themselves is whether a certain challenge, how accurate it may be, is a challenge for competition policy. The threat posed by climate change has never been more undisputed, but is it a challenge for competition law? Before competition policy can be engaged, it must be established that it is the right tool for the job. In other words, that the call for help fits within the goals and purposes of what competition law has been tasked to achieve. And as the scope of competition policy widens, this raises the related question of whether the current antitrust tools are perceived as up to the task. For example, with respect to policing competition in the fast-paced digital economy. If competition law is called to respond to new market problems, then what reforms are needed to give enforcers greater power to pursue their missions? Overarchingly, how far should we and can we expect competition policy to go as a tool to combat matters that are important to society and that may or may not fit within a traditional consumer welfare standard? These are some of the relevant questions that color the debate on the future of competition policy. And I'm delighted to welcome our panel to give us their views on these and other important questions. So let me now introduce you to our first panelist, Anne Doss, who is a practicing lawyer at Simons & Simons in Paris.
Thank you very much, Rosa, for the introduction and for setting the tone of the panel. I am very happy and honored to be able to be here today and to share with the audience a few thoughts about the future of competition policy. In my opinion, an expansion of powers of competition authorities may actually be needed. And I think that recent global events, such as the COVID-19 crisis, have shown that the application of competition law, for instance during times of crisis, can often be difficult. And I think we should prepare for future crises because they are inevitable. And this can be done in two ways, in two steps. First, we should review past enforcement and competition fraud policy during times of crisis. Second, we should identify key things to change. So the first step would be to conduct a thorough review of past competition enforcement. A very good example would be the COVID-19 crisis. Why? It's because during this crisis, there has been an unprecedented reaction from competition authorities. It is early to conduct a very thorough assessment, but I would like to make a few observations because there were both positive and negative things to remember. From the positive standpoint, we have seen that competition authorities are quite willing and able to answer undertaking needs within a very short time frame. And a perfect example would be the temporary framework, which was issued by the Commission in April 2020. This temporary framework basically helps businesses assess what kind of business cooperation is legitimate during times of crisis. After these positive observations, there are still a lot of negative things to point out. For instance, competition enforcement during times of crisis was slowed down, with, for instance, little or no downgrade conducting during the very core of the crisis. More generally speaking, there were regular calls from undertakings for more legal certainty. So after making this very quick review of competition enforcement during the past COVID crisis, we can try to identify what can we change, how can we better prepare. And I have a few quick suggestions. So first, we have seen that legal certainty is very important. So we could try to prepare from a procedural standpoint by setting a very clear procedural framework to be applied during times of crisis. For instance, an idea would be to introduce comfort letters in Regulation 1/2003 to better address the legal uncertainty a crisis can create. We can also think of a second idea, which would be to update investigation tools of competition authorities. We could try to develop remote investigation tools to remedy some of the practical constraints that we have seen as real during the COVID-19 crisis. And third, from a more general point of view, what could be done is to clarify existing legal tests. There are some practices that are very commonly used during times of crisis, and the Commission could clarify that. Actually, the upcoming revision of the horizontal block exemption regulation could provide the perfect occasion to clarify in a very clear guideline what kind of business cooperation is legitimate during times of crisis. So to conclude, I have made quite a few suggestions without food for thought. But what is very important, and what I would like to stress out as a final point, is that it is necessary to prepare for future crises. And why? It is simply because competition authorities need to be able to support the world's economies in their times of need.
Thank you, Anne. So our second panelist is Narita Nagin, and she works for a listed infrastructure company in Sydney, and she is joining us live today from Australia.
Thank you very much, Rosa, for the introduction, and Anne for your interesting ideas. Good afternoon, everyone. It's an honour to speak to you all today, and I apologise that I couldn't be there in person. My submission focused on climate change as the most important challenge for competition authorities in the next 10 years. Protecting the environment is an issue that's close to my heart because I was born on the island paradise of Fiji, which I'm still lucky enough to call my second home. Fiji is being severely impacted by climate change, despite being one of the smallest contributors to greenhouse gases globally. The Fijian village of Vundagaloa was the first in the world to be relocated in 2012 due to rising sea levels. So today I will discuss some competition law and policy ideas illustrated by sustainability examples. But these ideas can also apply to a range of other problems, including those that are not even here yet. I will speak about competition authorities' ability to focus on matters that are important by firstly using their discretion, secondly by pushing boundaries, and thirdly, by ensuring that competition law is not creating risks or hurdles that stifle genuine efforts by firms to innovate or operate more sustainably. So on my first point, prioritizing the right things. So as you know, competition enforcers typically have discretion in deciding what cases to pursue and which cases not to pursue. And in doing so, I think that they should take environmental considerations into account. So to the extent that customers value and make purchasing decisions based on environmental factors, competition really does drive companies to improve their sustainability practices. And in this way, it supports environmental protection goals. Competition authorities should prioritize and enforce vigorously the rules vigorously where the conduct of private firms hinders competition in a way that's likely to negatively impact the environment. And just adding to that, competition authorities must also carefully consider when not to take enforcement action by taking into account competition harm as well as any positive or negative social impacts or externalities when prioritizing matters. And that includes impacts on out-of-market consumers. So my second point is that sustainability is an important enough imperative for competition authorities to increase what is captured by competition law, either by pushing the boundaries or by advocating for changes to the law. So one potential change to consider is increasing the scope of competition law to include something similar to the authorization process, which is used by the competition regulator here in Australia. When initiatives or conduct that would normally breach competition law, the competition regulator can provide approval for that conduct if it believes that the public benefits of the conduct outweigh the harm to competition. This is known as a public benefits test, and the Australian competition regulator applies it on a case-by-case basis. So this allows the competition authority to consider anything that's of value to the community quite holistically that can be a public benefit, including the environmental impact on society and on future generations. And my final point is that competition authorities should be cognizant of and make efforts to reduce legal uncertainty, particularly for firms that are making sustainability efforts in good faith. So in conclusion, my view is that competition law and policy and the approach taken by regulators should evolve to keep pace with market dynamics and stay aligned with societal values and expectations. And while my ideas presented to you today are just that, just some high-level ideas, I hope that the audience will be motivated to think of other solutions for competition law to play a broader role in promoting sustainability.
Thank you, Narita. So now I'd like to introduce to you our last panelist, Martin Flora, who is a master's student at the Masaryk University in Brno in the Czech Republic.
Well, thank you, Rosa, for having me. It's a real pleasure to be with you talking about the future of competition policy. I think the pandemic showed us the real potential of technologies and the rapid pace under which they can introduce new solutions to the market. In the last decades, there were really important steps in the industry of energy or in the industry of pharmaceuticals. And this innovation trend will only speed up. And while this innovation is certainly beneficial for consumers, these innovative ways are also bringing the new scope for the market disruption and also new ways for market disruption. So I think to tackle these new ways for market disruption, the competition authorities have to develop new practices and focus on two things. And the first thing is to ensure reasonable market entry conditions, and secondly, to clearly communicate their regulatory intentions. So regarding this first point, these new technologies require highly expert knowledge that possess only a small group of people. And at the same time, every solution is protected by several patents. So this will end with patent battles and with the very opaque situation in the IP. For instance, in the biotechnology, we have a CRISPR this is called genetic scissors, and there are several legal disputes around this, and those who will win, they will have really great leverage in negotiating the license terms. So here, Commission should ensure that the market entry will really be clear. To the second point, regarding the clear communication, I think that the Commission should communicate proactively and clearly how it will conduct these new anti-competitive practices, and this will increase the legal certainty and thus promote the innovation even more.
Thank you. So let me open the panel discussions by introducing the first question for the panel. During its 2017 review of the Bayer-Monsanto transaction, the Commission came under unprecedented pressure from campaigners receiving 5,000 petition letters and over 50,000 petition emails to factor alleged negative environmental effects of the deal into its assessment. And Commissioner Vestager declined to do so, responding that while safety, environmental and climate change concerns are of great importance, they do not form the basis for a merger assessment. She continued to state that DG Comp's mandate is rather to assess the case from a competition perspective. So we assess whether the case would lead to competition concerns due to the negative effect on price, quality, choice, or innovation. The other concerns that you raised are handled by my colleagues and national authorities. Recently, however, there has been impetus by the Commission to incorporate environmental considerations into its assessment. And the approach has not only changed towards environmental considerations. It was not until only a couple years back that we saw that industrial policy has seriously entered the European vocabulary, coinciding with the changing approach towards state aid. And this brings me to the first question. Do you believe that there has been an expansion of the scope of powers of competition authorities? I'd like to give the word first to Anne.
So thank you very much, Rosa. And I think your question is felt very legitimate. In recent years, competition authorities have taken several decisions that actually may seem to broaden the frontiers of competition law. They have issued decisions that lead not only to competition concerns on the one hand, but may also lead to other concerns linked with other public policy interests, such as IP, data privacy, environmental, or even more recently, labor issues. And I would like first to give two good examples of that. The first example would be the German case, the Facebook case in 2019. And in this case, the German competition authorities' decision tackled the interplay between competition law and data privacy. A second good example could, for instance, be the ongoing press publisher case before the French competition authorities, in which we can see that there is an interplay and a relationship between competition law and the IP directive on related rights. So, for all of these new decisions, people have indeed been arguing that the scope of powers of competition authorities has been extended. And I do hear that there has been a lot of questions, a lot of debates about whether competition authorities can actually do that. For instance, if we take the Facebook case I have just mentioned, there were a lot of debates saying, should the German competition authority really have ordered the end of a privacy breach? And actually, in 2022, so 3 years after the decision taken by the German competition authority, there is still an ongoing request for a preliminary ruling before the ECJ, and this very question is being asked right now. So maybe we will get a clarification from the ECJ. But from a more general standpoint, at least in the antitrust sphere, I believe that in most of these quite new decisions, the so-called expansion of powers of competition authorities is based on existing competition law tests, because in each of the decisions taken, like most of them, competition authorities have tried to demonstrate that the conduct at stake actually has an impact, as Rosa said, on price, quality, choice, and innovation. In other words, on consumer welfare. So coming back to your question, yes, Rosa, I think that there has been an expansion of the scope of powers of competition authorities in the sense that they are now more willing to look at competition concerns that also lead to other public interest concerns. But I think it is rather a shift of focus in competition enforcement by a wide overhaul of competition law. I believe that competition authorities are still applying competition law and relying on the consumer welfare standard.
Okay, so Anne, you believe that also the new matters that competition authorities have concerned themselves with still fit within the consumer welfare standard. Martin, do you agree?
Well, and I actually think that this willingness to look at the other aspects of competition policy actually represents the extension of competition authority power, because when we the altering of the established practices, just in a subtle way, still deserves, in my opinion, the extension label. So I'd like to illustrate this by example at the Commission's decision to accept the referrals. In merger cases, even when the concentration doesn't fall under the national law. So this is meaning that new restrictions are being imposed on the undertakings, and the factual state as a result is that yes, that the new regulations is imposed, and thus this deserves the extension label.
Okay, so Martin, you state that competition authorities have actually extended the scope of their powers. Then my question is, do you agree with this extension?
Yes, but under certain conditions, because such an expansion must be grounded, especially when we use terms like consumer or environmental benefits that might be vague. So we should strive for as objective assessment as possible, and we might find those objective principles, for example, in the three-pronged tests in mergers, in merger cases. So we should ask, will this merger really benefit the consumers? Are those benefits merger specific, or are those benefits verifiable? And I actually think the Commission should always reason if these benefits will materialize, actually. And in this case of referrals is, in my opinion, good example of power extension, because big players may be strategically buying up startups to block competitive threats. The Commission showed that the current use of legal tools fails to address some of those mergers, so that's only reasonable to use tool with adequate competency in this regulation. So yeah, of course there might be case that none such a tool is found, and then the Commission must take on the role of legislator, but that's a very long-term process.
Okay, so Martin, you mentioned the example of referrals. Now, Narita, do you agree with the extension of the scope of powers competition authorities, maybe on a more general note, in relation to enforcement activity in general?
Yeah, thanks, Rosa. Yes, I do agree with the enforcement approach that the competition authorities have been taking. I think it's very positive that competition authorities are willing to look at anti-competitive concerns that impact on consumer welfare beyond just price, including things like privacy and environmental impacts, because these are also quite detrimental on consumers. So much of this change in focus is sort of a change in focus, I think, rather than an expansion of scope of competition authorities, because as Anne said, the existing tools are being used. So one recent example is the enforcement action that the European Commission took against Daimler, BMW and Volkswagen for colluding to prevent the development of sustainable technology, which is the case that Vice President Vestager mentioned today. So even though it is a new theory of harm, and it's the first cartel decision based solely on restriction of technological development and not on, the traditional price fixing, market sharing, or output limitation. BMW also claimed that it was uncharted legal territory. Despite all of these things, it was still a competition issue because competitors were colluding on an element of quality of the products, and normally they would compete on that. So that's why I think it was quite clearly in the remit of competition authorities, and it was aligned with the objective of consumer welfare. To future-proof, competition authorities need to evolve their approach to keep pace with market dynamics. So one example of this is that as sustainability becomes more and more important to consumers, competition on the basis of that is likely to intensify. And so collusion in relation to that is much more likely to substantially lessen competition going forward. And this is particularly relevant in technology markets as well, as many products such as social media platforms and search tools, they're provided to consumers free of charge. And without any competition on price, quality factors like the privacy of users become even more relevant because it's really the only basis on which these companies can and do compete. So in conclusion, my view is that as markets change, the change in focus of competition authorities is very positive. It demonstrates that competition authorities are continuously learning and developing theories of harm which are aligned to changes in the market and are therefore keen to face the challenges of the future. Thanks, Rosa.
Very well, but I think we cannot help but wonder that as privacy becomes a dimension of quality to justify enforcement under competition law, isn't this too much of a stretch of the traditional parameters of competition? Maybe against this background, let me go into the next question. So at a minimum, you seem to agree that the focus of competition policy and competition authorities has widened. How do you think this sits with legal certainty? So can legal certainty be ensured as competition authorities keep on concerning themselves with different and changing issues? And I'd like to give the first word to you, Narita.
Thanks, Rosa. So I'm sure we'll all agree that legal certainty is very important. And of course, guidance and precedents should be provided by competition authorities to the public. I believe that this is consistent with what is already being done. A lot of formal guidance is being provided to industry, such as the vertical guidelines that the European Commission is currently consulting on. So as Vice President Vestager said today, competition authorities must regularly review that and update the guidelines so that any emerging issues are also included in them to give an indication to the public on how competition authorities are likely to approach those emerging issues. I also think that competition authorities should be open to engaging with firms informally and publicising the fact that they're ready and willing to do that. This includes sort of providing comfort letters where appropriate. And I just think that if firms knew that or became more familiar with the fact that the competition authority is willing to do that, they'd be sort of more readily likely to get to involve themselves in that. So with comfort letters, the European Commission's quick and flexible approach during the COVID-19 pandemic was quite notable, including, for example, working with the Association of Pharmaceutical Manufacturers, Medicines for Europe, to provide comfort for the cooperation to address risks of shortages of medicines for the treatment of COVID-19. So I believe that competition authorities should continue this approach after the crisis. And particularly because comfort letters are quite a flexible tool. So, for example, depending on the competition authority's findings in its investigations, the letters could be limited to very specific initiatives and conditional on whatever the Commission thinks is important. So, for example, on the product being made widely available at a fair and reasonable price. And in addition, the competition authority can determine the length of time over which the comfort letter will apply, with any party seeking longer-term protection having to reapply. And at that point, the competition authority can verify whether the benefits that were claimed have actually materialised. And competition authorities could make positive statements as to what can be done within the boundaries of competition law when they don't see a problem with a particular initiative, especially for sustainability initiatives or other initiatives that have sort of a social benefit. And this can be in the form of speeches, decisions, press releases, a whole range of ways of doing that. And as Commissioner Vestager said today, this is something that the European Commission did in relation to the car manufacturing cartel that I spoke about earlier. Letting the public know what is allowable under competition laws is important, because a lack of understanding could stifle innovation as firms fear breaching competition laws. And then when it comes to socially beneficial initiatives, such as green initiatives, competition authorities can sort of publish legal opinions or that sort of thing, and think about other ways to encourage, for example, law firms to do the same, subject to client confidentiality issues and that type of thing. So these are just a few examples of what competition authorities can do within the existing competition framework and with limited resources to provide additional certainty to the private sector.
Okay, we've heard some interesting specific examples. Martin, what do you think about these?
Well, Narita mentions positive statements as to what can be done without the infringement of competition law. And I think this is very important in the area of sustainability, sustainable technologies, because I think that Commission has been more successful actually in the state aid area. Looking at the state aid guidelines, member states can get a pretty much clear view of what the Commission considers to be aid compatible with the internal market. And even though some guidelines need some revision, the states know that when the aid is aimed at the sustainability, it will be compatible aid. And on the other hand, such clear guidance is not provided in the field of antitrust, for example, regarding undertakings who wish to cooperate to achieve sustainable goals. But in the field of sustainability, where undertakings are often risk-averse, such guidance in the form of clear vision by the Commission as to what is competitive and what's not could actually be a game changer.
It's interesting that you talk about state aid, because I think that indeed, more than with regard to other fields of competition policy, in state aid law, the Commission has given rather extensive guidance on how it intends to exercise discretion. When looking at the state aid guidelines and interpretive frameworks, it is possible to distill the Commission's vision on good aid, which in turn reflect EU policy objectives. And it is along the lines of those guidelines that member states will want to design and justify their state aid measures, thus targeting the market failures that are favored by the Commission. And we can argue about the use of soft law as a policy instrument, But whether or not we agree, these guidelines and frameworks certainly give member states and undertakings an idea of the matters that are invaluable to the Commission. Similar to the way that national governments can distill what the Commission considers to be good aid, I think that undertakings would want to know what the Commission considers to be good agreements, for example, when cooperating on sustainability initiatives. So in this context, for example, the revision of the horizontal cooperation agreements is for sure welcomed. But let me go back to the question now and repeat it for you, Anne. So the question is, how do you think that legal certainty can be ensured as competition authorities keep on looking at new issues and challenges?
So thank you, Rosa, and thank you, Martin and Narita, for your very interesting thought. I thought you raised a lot of points about the need for general guidance and also the need for very specific guidance on a case-by-case basis. And I would like to stress out one point to complement what you just said. I would like to point out that businesses need to be able in the day-to-day business to assess and understand what kind of conduct is legitimate or not from a competition standpoint. It is very important for them because they need to be able to conduct risk assessments and assess precisely their compliance costs. And I believe that soft law guidance is the perfect tool for that. The return of comfort letters during the COVID crisis, in my opinion, a very positive move. Since the adoption of Regulation 1, 2003, businesses have however done a kind of self-assessment, but I think that the COVID crisis and recent global events such as the sustainability issues, which we have mentioned we have mentioned before, have shown that there is need for more legal certainty from the business. And actually, this need is very well understood by competition authorities, as Narita and the Commissioner Vestager just explained. There are three good examples for that. First, the COVID crisis, in which there were tremendous guidance from competition authorities, and especially the EU Commission, which was very active. And the second good example would be an environmental crisis. There have been a letter sent to the parties in the car emission cartels, but there have also been initiatives at national level. And for instance, I read that in January 2022, the German Competition Authority also issued something similar and assessed 2 cooperation agreements in the sustainability sphere and explained why these conducts were legitimate. And a third example would be non-related to the COVID and non-related to the environmental crisis, but would be a comfort letter which was issued in October 2021 by the EU Commission. It was issued to Gaia X, a non-profit organization active in the cloud sector. And the EU Commission took the view that it was necessary to answer this non-profit organization question about its rules of functioning, and it explained how it can be legitimate to organize its functioning in a compliant way. So coming back to your very interesting question, Rosa, I do agree that the recent intervention from competition authorities have shown that there is a need for more legal certainty and that companies need to be accompanied during this transition in their day-to-day business. However, I do believe that competition authorities are also very aware of that fact and they have started to act on that.
So before I move to the next question, let me remind you that you can raise questions in the WebEx chat, also when you're joining us from online, that we will take after these panel discussions and I will raise with the panel. So please do so. So for the next question, I touched upon this in my opening spiel. Is competition policy always the right tool to intervene, or are there other regulatory tools that may be better placed to address certain issues such as IP or environmental issues? And I'd like to give the first word to Martin.
I think the question is when the competition policy is the right tool to intervene. And in general, I think that it should intervene in the cases where, firstly, the other legislative tool creates some long-term market disruption, and secondly, this tool is not able to redress this situation. And I will give you a very specific example. Well, there's a intersection area between competition policy and intellectual property. And competition policy assessed usually the execution of IP rights. But for me, it's the question whether the possessment itself, the mere possessment of a patent, actually can be seen as the market distortion. And I take example from pharmaceutical industry, where the originator companies may issue so-called secondary patents. Those secondary patents, their intention is just to block other competitors to enter the market, and they don't benefit consumers. So, and what's even more important, the mere existence of them can prevent competitors to at least try entering the market. So I believe that there is a space for competition authority to use its power.
Interesting, because I think that in your specific example, Martin, some may also be more inclined to think that if problems arise from flaws or limitations to other policies, that solutions would first be searched for within the realm of those other policies. On the other hand, competition policy as a tool may be more preferred when we have more confidence in the self-corrective powers of the market, also depending on the time horizon that one allows for such forces to take effect. What is your take on this, Anne?
So I don't think that competition law should be used as kind of a catch-all tool or a silver bullet to cure all ills. Competition authority should only intervene when there is a competition issue at stake, because of one simple reason: this is actually the limit of their mandate. So it is very important that in each decision taken, where competition authorities are able to demonstrate that the conduct they examine has an impact on price, quality, choice, and innovations. In practice, I understand that things are really not so easy. There are competition issues arising in sectors that are already regulated under another area of law. And a very legitimate question in such instance is that how can we articulate competition law and that other area of law to better find a solution for consumers? So I have no easy answer to that question. If I had one, I would have given it. And I think that Martin's example perfectly shows that in practice it is very complicated, and like the interaction of IP and of competition law is one of the main debates currently. And I personally very regret that last year Nokia and Daimler chose to settle the case, because we could actually have had a good answer from the ECJ on the interaction of competition law and IP law in the context of friend dispute. But in these times of uncertainty, I think that one thing remains clear. It is not because a sector is already regulated and another area of law that competition law cannot intervene. A good example is ongoing discussion regarding labor markets and the application of competition law to such markets. Prima facie, the application of competition law to such markets is really counterintuitive. Workers are not undertakings, and these labor markets are very regulated actually under labor law, especially in France. So is there a scope, an area for competition to apply in such instance? I believe that yes. Why? Because there have been a lot of studies conducted recently, for instance, by the Portuguese competition authority. It has published an interesting study in April 2021, in which it basically tries to demonstrate that practices on labor markets may have an impact on competition law. And personally, after reading this, I was convinced that some wage-fixing agreements and some non-poaching agreements could actually have an effect on competition. So to come back to your question, Rosa, and to sum up a bit my positions, I believe that competition law should remain the right tool to intervene every time there is a competition issue at stake, and this regardless of whether this practice is happening in a sector that is already regulated.
I think you made a very fair point, Anne. So maybe even the fact already that competition policy is the one policy that applies to all sectors in the economy has extraterritorial application and may penalize companies far away from the EU already indicates it cannot become a tool to cure all ills. And now I come to the second last question. All of you seem to agree that the scope of powers of competition authorities have undergone an extension or at least a shift in focus. How do you think that this and any potential further expansion in the future will affect the action of other regulatory and/or consumer protection bodies? And this also relates to the former question. Anne, you first, please.
So, well, my first answer would be that your question is very complex. Why? Because the state of play of EU and national regulatory bodies is already quite complex in the EU, and this will only become more complex with the ongoing reforms. For instance, in the digital spheres, there will be implementation of the future DMA and the future DSA, and this will only make things more complicated. And let's take one example of this complexity. It could, for instance, be the fact that there are some competition authorities, such as in the UK, which wear other hats. There can also be consumer protection bodies, such as the CMA. But in France, it's not the case. The French Competition Authority is dealing with competition issues only. So we can see that because there are differences at national level, things are complex. And as I said, it will only become more complex in the coming years. I do agree that there is hence a risk of overlaps between the powers of competition authorities and of other regulatory bodies. This may have negative effects on the economy. We should not overlook that because of two reasons. First, this may have a chilling effect on the economy because of compliance costs. And second, competition authorities are not necessarily the best technically placed to deal with a very specific and technical issue. And in that context, it is very important to try to find a clear and coherent articulation. We should try to clarify what is the scope of competition authority and what is the scope of other regulatory bodies. It is a very difficult question, but I think finding an answer is really possible. And I have two very quick justifications for that point of view. First, my point is that the topic is really not new. There has been a lot of precedent in the telecom sector regarding the interplay between competition law and telecoms regulations. For instance, the EU Commission has issued several decisions in which it explained how it can be done. In 2011, in a Polish case, the Commission basically said that it could still sanction an abuse of a dominant position, even if the dominant undertaking was subject to very specific regulation, when it still had a marginal action to act, and thus it could still commit an abuse. And second, I think that we can find a solution. Why? Because of an awareness, a general awareness as to that issue of finding a coherent articulations. Competition authorities know that something needs to be done. I will take a French example because it's easier. In France, for instance, the French Competition Authority has publicly stated in 2020 that it will fully cooperate with other regulatory bodies to fight together and to find together solutions for green policy objectives. So there are cooperation initiatives being done at national level, and I believe also at the EU level. So in the end, should a clear and coherent articulation be found, even though this will be difficult, I believe that this will have the most positive impact on the economy, because having several authorities work together toward common goals is the best solution for consumers. In the end, this is what all these authorities are trying to achieve.
Do you agree, Narita, that cooperation between authorities is complex but possible?
Yes, I do agree that it is complex and possible, Rosa. And I agree with the points raised by Anne. I think that competition authorities and other agencies should have some sort of cooperation agreements in place, which includes processes for them to work together and also how matters will be allocated between them. In addition to what Anne said, the only additional point that I want to make is that this would also ensure that firms were not retried or fined multiple times for the same conduct under various different laws by different regulators. If they were, that would be quite oppressive and unfair, as well as against the double jeopardy principle. So in summary, the double jeopardy principle means that the same person cannot be sanctioned more than once for the single unlawful course of conduct where sanctions are designed to protect the same legal interest. One recent example that I can give you is bpost in Belgium. So bpost was first fined by Belgium's postal watchdog, which found that bpost's rebate system breached sectorial postal rules, and subsequently after that they were also fined by the Belgium Competition Authority, which found that the same rebate system was an abuse of bpost's dominant position in the postal sector. So this is an ongoing matter, and the European Court of Justice ruling on this is pending. So when there is an overlap between the functions of regulators, this must be managed by open and transparent communications between the different regulators to avoid undesirable outcomes.
I have one final question for you. So following the panel discussions and the conversations we've had in preparation for this conference, I've gotten some idea of your views. Now I'm very curious. If you could make one proposal for a reform, what would it be? Narita.
Well, Rosa, as you know, I'm an Australian competition lawyer, so I have had some experience with the Australian Competition and Consumer Commission's authorisation process. So what that is that, the firms can come to the ACCC if they're thinking of doing something that could breach competition laws, and then the ACCC can then authorise or permit them to go ahead and breach the competition laws if it finds that there's a public benefit which outweighs the anti-competitive effect. So this is known as the public benefits test. So parties seeking authorisation typically provide the ACCC with a lot of quantitative and qualitative information relating to the public benefits that they are claiming. And then the ACCC balances this against the likely harm to competition and then decides whether or not to authorise the conduct. So adding this type of option for clearance is a reform idea that I think is worth considering, because it provides flexibility to the competition regulator to consider environmental, safety, security, privacy, and a whole range of other social issues, in addition to economic issues, in assessing any proposed conduct, which really gives it a much wider lens to make decisions that truly benefit society.
Thank you, Narita. I was really not aware of this Australian specificity. From what I hear, I think that the public benefit test that is currently used in Australia is really interesting. It could represent it interesting food for thought for the EU. But personally, I don't really believe that there is a need in the EU to introduce such a wide and new legal tool in the form of the test you just mentioned. I can't help but ask myself two preliminary questions. First, my immediate question would be, should competition authority really be able to consider such wide public interests? Like, shouldn't it be left to legislators who actually are elected and have the democratic legitimacy to consider such questions? And second, I'm asking myself that we have seen, for instance, during discussion regarding sustainability objectives, that there have been a lot of debates about how to quantify environmental benefits. If we open such a wide new legal tool and new concepts such as public benefits, wouldn't it really be complicated? Wouldn't it create legal uncertainty? Is it really worth it? Do we really want to increase compliance costs for businesses? Actually, I don't believe that there is enough evidence that would call for a wide overhaul of competition law. things can actually change and are starting to change with that. We have talked a lot about sustainability, and I think this is the perfect example of things starting to change. Last September, the European Commission has published a very interesting policy brief in which it basically announced that it would change this approach on a step-by-step basis. It could notably reflect on how to apply Article 101.3 to sustainability agreements. And actually, in the end, this might actually lead to a change in the decisional practice of the Commission. Personally, this approach has my preference. Why? Because it's a step-by-step approach. The EU Commission is cooperating with businesses, with national competition authorities too. So in the end, the Commission may be able to tackle and deal with a new public interest, but also provide enough legal certainty for the business.
Thanks, Anne. I do agree with the points that you've raised. Like, I agree that it's quite a wide test, and obviously there is a question about, is the Competition Authority the right one as the right person to decide on public benefits, given that they haven't been democratically elected. But just leaving that sort of philosophical question to the side for a second, I guess. The other point that you made about legal certainty, I will touch on that in my response, but I just wanted to sort of do it in the context of Article 101.3 holistically, and just sort of describe the differences between the public benefits test and Article 101.3. So the biggest difference is that Article 101.3 only applies to conduct where consumers get a fair share of the resulting benefit. So this requires that consumers of the product are not worse off on balance. So the public benefits test considers the benefits to the public as a whole, rather than being limited to consumers of the particular product. So in a nutshell, it's the difference between consumer welfare versus total welfare. So for issues like sustainability, I think this is quite important because the benefits of sustainability are global and go to future generations as well. So it might not always be focused on consumers of the actual product itself. And therefore, these types of benefits are sort of more likely to be captured in full by the public benefits test rather than Article 101.3, I think. And then my second point is that Article 101.3 applies to anti-competitive agreements and concerted practices, whereas the public benefits test has a much broader application, including on like abuse of dominance matters and mergers. So it covers like a large range of possible conduct. And then my final point is that the public benefits test in Australia is not available as a defence after the conduct. So it can only be used as with express permission of the Competition Authority in a process that's called authorisation. So this means that before starting the conduct, the firm and the regulator already have legal certainty. And so it actually does promote legal certainty to an extent in a similar way that comfort letters might, because it sort of is, you get it before you sort of start the conduct. And finally, I appreciate that it is quite difficult and complex. Sustainability benefits are notoriously difficult to credibly quantify, and the ACCC does sort of a qualitative assessment of the benefits and whether they outweigh the costs. Sometimes they are able to get data to quantify it, but in a lot of cases it is qualitative. And I don't think the complexity should really deter or be a deterrent in changing the approach of competition authorities, because in my view, competition authorities very often conduct very complex analysis, including sort of like forward-looking merger reviews and things like that. So I think competition authorities are quite used to quite complex matters. And so, I mean, I think that I would support a change that allows for benefits to the wider society to be taken into account. And there could be a way to do it in sort of stages. So to begin with, the test could be used in assessing sustainability agreements and then be used sort of in other areas over time. And this would benefit the entire society and support the climate standard to which the European Union is bound.
Okay, thank you, Narita and Anne, for these reform proposals. These were your last statements. Martin, do you have a last?
Yeah, well, I would definitely propose the definition of new theory of harm regarding the patent issue, as I mentioned before, and I wouldn't fear to even bring it to the court if some undertaking will will disagree with this new theory of harm. And secondly, I see that we are a lot of talking about the proactive approach of competition authority. We mentioned a lot of times the comfort letters, so maybe I think, as Anne said in her opening spiel, it would be very useful to reintroduce guidance on comfort letters.
Okay, so to wrap up, the fast developments in the digital economy, but also the disruptions caused by the current crisis, are not only challenging existing markets, but also existing policy frameworks. Yet this panel seems to agree that while the focus of competition authorities has shifted, this focus has remained within the realm of competition law as we know it. This panel did discuss the possibility of potentially complementing the consumer welfare standard to accommodate for other public interest, while remaining conscious of the questions that this raises about legal certainty and potential overlaps with other regulatory and policy fields. I think the panel did a great job in covering these different topics related to the scope of powers of competition authorities. Maybe one question remains. So as the world around us and market dynamics change, the question that has repeatedly sparked debates is whether the consumer welfare standard is up to date. Following the discussions we've had today, this question may rather be, how far can we stretch it? And with that, I want to close the panel discussions, and I'd like to open the panel Q&A. And before I do so, I will repeat some of the rules for the interaction during the session. So if you're in the audience, just raise your hand. But if you're following us remotely, just type your question in the WebEx chat, and Anna will give the questions to me, and I will ask you to raise the question yourself. And before you do so, say quickly your name and your organization. So I see a first question, maybe in the end there in the back.
Jean-Pierre Röhmen, LLM student at Trinity College Dublin. So my question is, if the powers of national competition authorities are extended, how would that affect coordination with the European Commission? Thank you.
And do you like to take this question?
Yes, I can have a first go at this question. So indeed, your question is very legitimate, especially in France. We have seen that the French competition authorities have taken decisions that has an impact not only on the French market, but also on a wider European or even global markets. And a very good example of that would, for instance, be the Google settlements in the ad tech industry last year. And in this case, the French competition authority imposed, they agreed on certain kinds of remedies and agreements with Google, which actually has an impact on the broader world and on Google's broader worldwide services. So we can see that the fact that there is increased power of national competition authorities raises a question of competence at national and EU level. Personally, I don't think that it's because a conduct may have a wider impact that a national competition authority shouldn't deal with that. We have seen in recent years that national competition authority has been like a driver for competition enforcement. They have launched a bunch of sector investigation, a bunch of market studies, and it has really helped competition enforcement evolve in the past years. For instance, earlier this week or late last week, the French competition authority has launched a study in the cloud sector. It I don't think that it has only a national impact, it has a worldwide impact, and I believe it is very positive.
Okay, thank you, Anne. I see a lot of raised hands in the audience, but I also need to give the remote audience the chance. So let me first pick a question from there. And I see a question from Alexander. So I think you will be, you can unmute yourself now and raise your question. Sorry, Alexander, I think we cannot hear you. No hybrid conference without this happening, right? So I think maybe we can also take first the question from the audience and then get back to Alexander when these questions have been solved. So I see a raised hand in the middle.
Oh, thank you. My name is Doris Hillebrand. I'm an economist at EMC. First of all, I want to congratulate you to this amazing conference. I appreciate that you're really discussing on a very high level. The panel was about extending the scope of the competition authorities or extending or maybe even changing competition law. But being an economist, have you ever thought about the possibility that when you talk about the consumer, like in Article 113, that the consumer has two different meanings? It could be the Chicago School meaning, where the consumer is related on prices and efficiency, but it could also have the meaning, what we see in the Treaty of Lisbon, that the consumer is a citizen. And when you are qualifying the consumer as a citizen, you do have the price, the quality effect, you have the Green Deal included, you have the data protection included, you do have sustainability included. Meaning that when you are going to start to do some analysis and do not relate to the consumer but to the citizens, you would not have to change the law and you would not need to change the scope of the work of the competition authorities. And you mentioned on the Facebook case, that is actually what our federal court in Germany did by applying or by ruling on the Facebook case. The court was saying, well, we are talking about German citizens which have data protection values and price-related aspects. So have you thought about this as well in your preparation?
Yeah, I have seen that in a German Facebook case, actually the German Competition Authority has really relied on the market studies that showed that data privacy has become a parameter of consumer choice. So I think that was really interesting because that shown that the parameters of competition may evolve, a consumer may change, as you said, a consumer from more competition standpoint, almost more traditional standpoint, and as a citizen. I don't think that we should try to stay rigorous and maybe not broaden like every test and to consider a consumer from a citizen standpoint, but we can try to prove from an economic standpoint, as you mentioned in the German case, that a change of the parameters of competitions can lead competition authority to take into account new needs, new characteristics of the products when they are important. Not every characteristic of a product is important, but when they are for consumers as a group, as a significant group, they should be taken into account, yes.
Okay, thank you. I think we may try again with our digital audience. We now have a question from Sebastian. Sebastian, maybe.
Hi, can you listen to me?
Yes.
Okay, thanks everyone for the conference and the panel, very interesting. So I have a quick question to Narita, and it is, how do you envision the use of this discretionary power in case selection that you mentioned by competition authorities? And how could the criteria to select the cases be justified?
Thank you for the question. It's actually a very good question. So, I mean, my view is that competition authorities, as it is, always use their discretion to choose between different matters that they look at because of scarce resources. So I believe that, part of that could be looking at sort of other factors, such as the harm to society in choosing what cases they take on. So I would think that it was sort of almost a net public harm kind of thinking, because you take into account what the harm is that's caused by the actual conduct itself, and then you think about, like, well, are there any sort of positive benefits to society? Are there any negative benefits to the society? And then sort of take all of those factors into account when deciding that what matter to take on. So, I mean, I appreciate that it sounds like a very time-consuming task for competition authorities right at the start of their enforcement action. And so I actually think it's more of a qualitative assessment rather than, getting data and looking at it. It's almost like a common sense approach to be like, okay, well, this is what the competition harm is, this is what the benefits are to society, and this is what the harm is to society, and sort of forming, on a case-by-case basis, deciding on that basis whether or not to proceed with enforcement action.
Thank you. Okay, I think we can now try again with Alexander, because everyone deserves a second chance. So let's try again. Okay, maybe not. Then let's see if the audience here has another question. Yeah, I see one in the middle again.
Thank you for the conference. My name is Christophe Carretti. I am a doctor in law and economics on big data and competition law. I'm working right now at Bruegel on competition and digital policy. So you mentioned the idea of confront letter. Actually, it's not you. President Kramer issued a similar idea in 2019. But I don't know if you take into account in your analysis the fact of enforcement cost here. Because this is great to say, let's go for a confront letter, but if every company go to the competition to say, hello, can you please tell me if my practice is good or not, it will have an impact on enforcement here. And they have the resources and also the expertise to do that, to forecast whether the practice may have an impact, and also have the guys be able to analyze every case. This is the reason why in merger control we have a threshold and not like before the obligation to notify all the merger before the commission, because it was impossible to control everything. So this is the first aspect, the enforcement things. The second one is about the dissuasive effect. If you have a confront letters, that is good, but the goal of competition law is also to dissuade companies to do bad practice. So if you give the green line first, they said, okay, guys, we are okay, we can do everything as long as you have the green line from the commission or from the competition authorities. And this may, say, well, I can do this practice because the commission didn't say anything on that, and well, she didn't do the job on time. So my question to you is, do you think, if you take into account this element, that confront letter is a great idea, first of all, and I agree it's challenging to see competition policy because it's evolving fast, but competition is evolving also very fast. The world of today will not be the world of tomorrow. We can see a move from mobile to IoT device. So instead, perhaps do things a move towards more grid line on how they should behave, which tools they can use, and which kind of access, to the market is a better option than just confront letter at the end of the day.
Apologies, could you repeat the last bit of your question?
The last things of my question is, instead of comfort letters, saying general guidelines on if you want to enter into a market tomorrow, for example, tomorrow will be the metaverse, or it will be the Internet 6 market, I would say it broadly speaking. The condition of access to this market, you can enter this, but you have to behave, I would say, in that way.
Yeah, I understand. First, I really do hear your concern about the finite resources of competition authorities. I do understand that they cannot look at everything, that their teams are like what they are. There are a limited number of people working in DG Comp and in national competition authorities, but I don't think that should be a deterrent to issuing comfort letters. I think that a middle ground can be found between accepting every comfort letters. I understand that companies may be tempted to send everything to the Commission, but the Commission could prioritize comfort letters in such a way that they first address novel issues that really raise questions from the competition standpoint. And I don't have a precise idea for guidelines to introduce such things, but in merger controls, as you said, we have thresholds. So why not have it for comfort letters? We should try to find these thresholds, to try to define these thresholds, but finding thresholds is possible. And I believe it is a better solution than having a kind of vague comfort letters issued on a case-by-case basis with no legal actual value. I think this is a middle ground. Sorry for the Commission. I think this is a middle ground between having comfort letters issued without a legal basis and a clear procedural framework, and having competition authorities working with their finite resources. As to the second part of your question, like having competition authorities kind of approve or issue guidelines before having a market entering into a new market, the idea is quite new to me first, but my first impression is that it may have a chilling effect on innovation, because when a market is created, there's no like green light, I'm creating a new market, green light, I'm creating the metaverse. It's a step-by-step approach. If we really have if the Commission conditioned access to a market, the Commission would be kind of acting as a gatekeeper for innovation. So,
very interesting dialogue. I would ask the others. Sorry, I didn't hear who was speaking.
And I think Narita wanted to answer.
Sorry. I was going to say that I want to ask you if you want to raise something, but not too long, because I see we're already other questions coming in. So if you want
Rosa, thank you. I think it's a good question about the cost of comfort letters, and to be honest with you, I hadn't thought about that at the time when I was thinking about all of these issues. But I just have an idea, which is kind of following on from Anne's idea of prioritization. The way that it works in Australia in the authorization context is that there is a fee for firms to apply for a comfort letter, and that or an authorization, which is quite similar to a comfort letter. So that is probably something that you can consider as well. So that could allow for competition authorities to increase their resources.
Okay, thank you. Then I think there's another question for Narita, raised remotely from Raluca.
Hi, I hope you can all hear me. Thank you for such a wonderful discussion so far. And my question is regarding the public benefit test. This seems to be a rather qualitative approach that leaves a lot of leeway for firms. How would you balance this with more quantitative tools?
Yeah, thank you for that question. It is quite an issue because there is a lot of qualitative assessment that the ACCC does. These days there are ways of there's economic analysis that can be done on the environmental issues that arise, and so I think that there is some means. I'm definitely not an economist, so I can't go into details about that. But I think there are ways, from what I understand, that they can use to quantify to some extent. But given that climate change is quite difficult because it is a global issue and the benefits are global, I think it is quite difficult to quantify. I know that the ACCC recently looked at a matter in relation to batteries, and in that there was sort of a cartel arrangement which it authorised, because the firms involved would charge a small levy to customers, and then they would use that to appropriately dispose and reuse the end-of-life batteries. So the ACCC looked at that in really quite a qualitative way to just say, okay, well, these are the environmental benefits, and then the cost to consumers, on the other hand, is actually quite small, because I think it was a few cents per battery. And so they took both of those into consideration and balanced it and and decided that the environmental benefits would be likely to outweigh the costs, that small cost. So I'm sorry, I can't give you much more information than that.
That's perfect, thank you.
Okay, I'm not sure if there are any other questions in the room. In the back, yes.
So as a first one, my question is about cooperation, competencies, and legal barrier. So those upcoming challenges with the digital area, the environmental concern, those do not have any borders. Those are completely global issues. Therefore, do you believe that it would be desirable and realistic to work toward a form of global framework and global enforcement of competition policies?
Who wants to go first? So personally, you're saying that global enforcement would be better to deal with global issues. I do agree, but I wonder if that's really possible. Like recently, we have seen a lot of national divisions, a call for more national industrial policies. And I think this call for a global competition policy would be perfect, but would be very hard to achieve. So I believe that doing things at least on a regional level, at the EU level, at the US level, at, for instance, the Chinese level, can have an impact on competition, even though I do agree that having a kind of Korean global approach to what Korean ills of the world's economies is desirable.
Yeah, I think it would be great if there could be sort of global enforcement, but I agree with Anne that I think it is something quite difficult to arrange. It would need a lot of agreements between a number of different countries all over the world. It's already hard enough to do it within sort of a small region like the European Union, but to do it sort of globally would be quite difficult. And I think one of the issues would be the geopolitical issues between countries. So I think that would be quite difficult to navigate and come up with something together. Yeah, it would. I think it's a good idea, but I think there'd be a lot of work involved, and you'd need the agreement of a number of different parties.
Okay, thank you. I think we have one last question. So this will be the last question we take, and it's from our remote audience, from Lucas Klaassen.
Hello, can you all hear me?
Yes.
Perfect. So you talked a little bit before about labor laws in relation to competition. And obviously we have the Albany case from '99 from the ECJ. And I was thinking, I would like to hear you elaborate your thoughts on that ruling and your thoughts in general about the subject, basically. And thank you very much for an interesting conference once again.
Could you please repeat the name of the case from the ECJ you just mentioned?
The Albany case regarding collective bargaining, where basically ACJ exempts collective agreements from the realm of competition law.
Like, I was not aware of that very specific case. I do agree that recently the Commission has also issued guideline on collective bargaining between self-employed undertakings, and I think that this shows that the frontiers of labor law are currently expanding because there are a lot of self-employed workers and a lot of workers that can be considered as undertakings, even though in practice they may have the same bargaining powers as normal workers, and at the same time the frontiers of competition law are also evolving. So I think that collective bargaining in such instance could fall within the scope of competition law if it's between undertakings, but it's already quite regulated in France under labor law, so I'm not quite sure of the future articulation between competition law and labor law in that respect. Thank you for your question.
Thank you. So Rossi just joined me on stage, and I told him we would stop, but he wants to ask a last question.
Sorry. Oh, I should have done this before. I didn't. Hi. So thank you for letting me ask a final question. So I was thinking about it while you were both speaking, Anne and Narita. So I feel a tension between your approach, Anne, which is a bit more incremental, and what I sense your approach, Narita, would be a bit more for speed. Do you feel there's a tension between these two? And if you had to choose, if there is a tension between these two, and you absolutely had to choose one of the two, which one would each of you choose? So that's my question. I'm putting you on the spot, sorry.
Everyone does.
Do you want...
Yeah. Well, yes, Rossi, there is definitely a little bit of a tension there. I think because I feel so strongly about the environmental benefits or the environmental issues, that's the key reason why I think that some drastic action needs to be taken in most situations, like in relation to all the other expansion points like privacy and all of that. I'm quite happy with the approach that Anne's actually suggested, because I think it is quite sensible to take it slow and sort of incrementally. But I think with environmental issues, I think it is the time to take some drastic action now.
Anne, do you want to respond to that?
Yes. I also think my position is quite influenced by my personal belief and work experience. I work as a lawyer, so I'm constantly doing risk assessments, analyzing practices, trying to identify what is legitimate. So I'm particularly sensitive to issues of legal uncertainty and certainty in my day-to-day work, and this is why I would rather advocate for a step-by-step approach. But I do think Narita's positions brings about a very positive energy in competition enforcement that should kind of be the focus, not exactly the focus, but behind our heads when competition authorities are trying to expand their scope of intervention to remedy what are market issues that are really there. So I don't think there is a small tension, but I don't think it's really contradictory. It's two complementary approaches, and maybe somewhere in the middle we can find the right answer for the economy.
Great. Thank you.
That was really great, yes.
Yeah. Thank you, Rosa. Thank you, Anne. Thank you, Martin. Thank you, Narita. Guys, if you're not aware, Narita is joining us from Sydney, so I invite you to check what time it is now in Sydney. So please, a big round of applause for all the panelists. That was great. And thank you for the audience for your insightful questions. I believe one of the questions came from Chile, so thanks a lot for watching us all over the world.